Hello, everybody. Welcome. We have another interesting naturalization mandamus case. So this case was filed in the district court for the Northern District of California, and as you know, California court's a little more plaintiff friendly, and but they did grant the motion by the government to remand, means to send it back for the government to make a decision instead of the court making the decision regarding naturalization. So let's take a look. In June 2023, he filed a petition for the court to review application for naturalization, or alternatively, he's requesting the court to compel USCIS to adjudicate his application for naturalization pursuant to the Mandamus Act. Defendants filed the government filed a motion to remand the matter to USCIS, contending the agency is prepared to adjudicate, and they're saying that they'll do that within 30 days or the issuance of the order. And then he filed his opposition, asserting his position against the remand. And for the reasons set forth below, defendant's motion to remand is granted, which means that it goes back to the government because they said that they'll try to issue a decision within 30 days. Okay, so just a quick background on this. This plaintiff is national of India, Tibetan descent. He became a legal permanent resident through marriage to a U.S. citizen. The U.S. citizen filed an I-130 petition for a relative to bring him to the U.S. to live with her. The I-130 petition was approved, and 2 years later, U.S. State Department issued an immigrant visa for him to enter the U.S. In 2018, however, they got divorced, and on or about 2020, end of 2020, he filed his Form N-400 application for naturalization, and he had his naturalization interview, and then there has been no action taken since February of 2022. And he made numerous inquiries to USCIS through the case status request tool as to why his case is taking too long than usual, and he didn't receive any kind of response. The government acknowledged that the application has been pending beyond the average processing time for an N-400 at the San Francisco USCIS field office. They attribute this delay to USCIS investigation regarding his eligibility for naturalization, including whether he was lawfully admitted for permanent residence. And then USCIS has since concluded its investigation, indicated on the record that it is not aware of any basis that precludes a grant of application for naturalization. So upon hearing no response from USCIS on his case status queries, he's hired an attorney, and his attorney sent a draft federal complaint to USCIS May 2023. And in June, he received a call from his ex-wife, informed him that two USCIS agents had gone to her house to ask questions about him. But she was at work, and they started questioning her current partner, who was at home. According to the defendant, in July, they offered the plaintiff, the person that's asking or seeking citizenship, the same remand terms they're proposed now, which is to adjudicate his application or make a decision on his naturalization within 30 days to be included in a proposed stipulation to remand. But he rejected that. So some of the legal standard that the court has used, we heard this before, USCIS fails to adjudicate naturalization application within 120 days after the date on which the agency examination is conducted, an applicant may obtain a hearing in district court. But most people wait about a year after that to see what's going on. So, and then the discussion section says, first and foremost, the court has remanded naturalization application to USCIS on numerous occasions because there's deference to agency's expertise in investigation, fact-finding, adjudication for application for naturalization, and USCIS is ready to adjudicate his naturalization application within 30 days of remand. But his main concern was it will lead to further delay and deny his application and he's forced to exhaust administrative remedies before returning to court again. However, the USCIS, the USCIS had issued a notice of intent denied, but he's talking about a different case. In this case, there's no notice of intent to deny has been issued, nor USCIS at any point presented to the court that intended to deny his naturalization application. But to the contrary, it says that the USCIS has represented the court on record that he's not aware of any basis that precludes granting him an application for naturalization. And then the court goes on to say he doesn't cite any legal authority for USCIS ability to question witnesses who volunteer. They're talking about his wife and partner voluntarily agreed to talk to agents. So, as part of agency's investigative power when it comes to adjudicating naturalization application, there's no evidence to suggest that Mr. Owen or partner's decision to speak with the agents was not voluntary. Moreover, USCIS authority to investigate the circumstances of his permanent residence. He says that the remand is not warranted in this case because delay in adjudication for application, naturalization application is substantial and unreasonable. But the court is saying that it's really not that much of a delay. And the court is saying that the government has explained the reason for the delay because it was doing an investigation concerning his permanent resident status. And the court is saying that part of the delay may have come from the plaintiff himself because the defendant government, USCIS, did offer to adjudicate within 30 days, but he had refused that. Okay, so for those reasons, the court is going to remand this to USCIS for them to make a decision within 30 days. So that's how it typically works, or is supposed to work. So anyway, if you like this, subscribe, and give me a thumbs up. Thank you very much. Bye-bye.